continues its work today, and we are going to talk now about decentralization, in particular about such a very important aspect as the land relations. As you know, the last week the Parliament adopted a number of the draft laws through which they delegated to the local authorities powers regarding the registration of the legal entities and the real estate, and they provided necessary resources for implementing these functions. But the issue of the land relationship and the management of the land still requires resolution. And why, without resolving this issue, decentralization cannot be considered as an efficient reform? This will be told to you by the Yuriy Hanushchak, director of the Institute of Territorial Development, advisor of the Ukrainian Switzerland project DESPRO, Reanimation package reform expert. You have the floor, Yuriy. Good afternoon. And there is a very popular idea or the requirement. Let us delegate the land beyond the boundaries of the populated area for the management to be provided by the local village councils. I would like to talk about this specific thesis and try to explain to you what's the problem associated with that. First of all, we are talking about the constitutional positions. The constitution fixes that the local governance in the today's version means the rights of the small cities, villages, and their united communities to exercise the local governance. In other words, to provide some local services. So please, I would like to draw attention. The right of who? Cities, villages, the populated areas, and their unification. We are talking about the unified communities, which are being created today, 179 in number. They could be considered as such, but actually, beyond the boundaries of the populated areas, they will not have the complete jurisdiction over those areas. So we face the problem proceeding from constitutional terms and conditions. The constitution doesn't have such the term as administrative territorial unit or such a term as the omnibus, let's say, authority of the local communities. We can consider territory Ukraine as let's say the pun or let's say with some raisins. And the raisins are, let's say, populated areas. There are some big raisins or even peanuts, I would say, with the biggest cities. They have more authorities like the small raisins like the city or town of the district importance or a village or the populated areas. And then this soft bread, so to say, or the duff, which is the territory. So the city or the village plus the district is the district city according to its authorities. But if you take specifically the district per se, then this city will manage the lands of their villages within the boundaries of the populated areas, and district by the state committee for land will be managers of the lands which are situated beyond the boundaries of those populated areas. So we shouldn't think that we are dealing with some kind of usurping or whatever, but new constitution amendments to be introduced into the constitution. We are talking about all the areas to be involved, meaning that the local authorities or governance will be exercised by the local council directly or through the bodies of the local governance, and the basic is the community. Then the next sub-regional level is region, district, and the regional, the district, including the regions and their populated areas. And we are talking about the administrative territorial unit, which is like that. The territory of Ukraine is divided into the communities. By this, we actually provided for the, let's say, all the places ubiquity, so to say. In this way, we can talk about the jurisdiction of the community over the whole territory without any holes. Now the next step related to the land per se or proper in the existing or the efficient constitution in the list of the material reserves, the basis of the material financial basis of the Salgurans, they did not mention the land. They have the budget and the other material values. In the next one, the land is number one. You're talking about the items. So when we're talking about the adoption of new amendments to be introduced into the Constitution, we can, or rather we must, to spread the jurisdiction of the local governance bodies, communities, I mean, basic levels, over the whole land, which is within the jurisdiction of the community. So again, no holes. Why I don't want to use, and I believe the improper, to use the such a notion as management, because management is only one of the components of the legal term or notion as the ownership, because we have the ownership, we have the property, we have the use, and we have the management. And the management disposal is the worst possible tool of managing of the land, because you can dispose of something once only, and then that's it. That's why I use the word management, not disposal. And there is another argument against the law where they use such a term as disposal. This argument is a corruption argument. Those people who take the bribes in order to sell the land, whether this is the state committee for the land management or the local council, it doesn't matter. So we have to bring to order, our legislation. So if you're talking about the disposal, if it's necessary, be transparent. So nobody could accuse let's say the bodies of the authorities that there is some kind of award to the head of such an agency or the body. So what they're doing now, what is being done now, they are working on the draft law on the plan and documentation when they introduce such a notion of the plan of the community territory. Plan of the community territory means description of all the lands falling within the jurisdiction of administrative territorial plan of the community. It has to replace the general layout or general plan of this village or populated area. If you're talking about the town planning element, it will be a component of the plan of the community territory. But we are going to provide that depending on this or another village populated areas, the demands or requirements for such plan be different. For the cities, it's a more complex, complex story, because there we face the problem or the issue of the spatial planning. As for the villages in populated areas, when the provisions for administrative units, we are talking about the plot of land related to this or another housing estate. So this is a lower level. So the plan of the community territory will be will cover all the territory and describe all the lands. Since as any other planning document, it has to be approved by the a local governance body, but is developed as by the certified institution organization. In this case, such a plan has to answer the question: number one, what is the situation today? What kind of use of the lands is today? What can this use of land be tomorrow? What are the prospects for the development of this specific community? We are talking about the land management. When approving this plan, the management of the community will have the right and the obligation to pass the decision regarding the changes to be introduced in this plan. You remember Saakashvili always says that we have to give the opportunity to change the objective of this plot of land use. We can do this only when we have such a plan and document approved, because this document is to demonstrate and indicate how and what for we can change this kind of the objective of the use of this land. We have some of the lands which refer to the reserved land, or for the agrarian or the agricultural purpose land. For example, we have an investor who says, "I would like to build something here. I would like to build a plant here," or there is a developer who has a certain plan and he says, "I would like to build here a cottage settlement here." So if you're talking about the allocation of such the promising lands or prospective lands, where according to this plan they can use this specific plot of land for this kind of the construction work, and within the this within the framework of this plan, which is approved by the community, they can take care of the processes which have to be provided for by the legislation specifically. For example, elimination of lands for the social needs, then the legal clearance of this territory, then cleaning of this territory or the preparation of the site. Number four, providing all the engineering underground lines for such sites. And number five, the sale of such sites to to a investor. This is the actual of those things which exist in all the civilized countries. If we are talking about the land management, I emphasize management, not disposal. In this case, the investor knows that this site costs such and such amount of money, and the contract makes provision that all the necessary underground power, water, and something else supply lines will be provided, for example, to avoid the situation when the plant is built and then the electrical engineers come to you and say, now pay for the connection of your plant to the power grid. In this way, we'll be able to involve investors only in the case when we have such a transparent system of land management. In this way, thus I can foresee that in the future we'll have the law which make provision, first of all, for the right to manage the land on the whole territory of the jurisdiction, which is given to the United Territorial Community in compliance with the perspective plan and the condition number two, provided that the plan documentation is approved for the certain territory of this community. Those are two conditions when we can actually talk about the land management. Another position, introducing amendments into the land code when we are talking about the ownership. non-disposal but complete package ownership of the land, plots of land of public ownership. Of course, we have to change the formula which exists today. In other words, whatever is beyond the boundaries of the populated area, a priori belongs to the public ownership. It's not. This is the wrong thing. I believe that there must be a different approach. Whatever land belong to the state according to the plan of documentation. For example, railroads in the right-of-way areas along the rails. For example, the roads of the public areas and those rights-of-way areas. Then the woods and the forests. This is something which are supported by the respective documents, and this must be referred to the state or the public ownership. All the rest should be communal, regarded as communal property. Another position which is mandatory in order for us to have a comprehensive package of documents, you're talking about the procedure of, let's say, of changing the type of the public ownership of the lands to another another form of the ownership of those lands, and this has to reflect the procedure which exists in the European countries, specifically the right to land, to the plots of land, should be given to the powers or authorities which which the state has and the local governance bodies. So if the state or the country has to build some kind of facility belonging to the state property, for example, some kind of the specific shooting range or whatever. So this has to be sold for 1 hryvnia from the communal property because we have to have some financial support document. But we have to understand from the very beginning that neither the public nor communal property or ownership has to bring any kind of, must not be profitable. So the lease or the rent is the worst which could be in the system of the property management. We're talking about the public property management. I mean those lands which belong, which are not included in the populated areas, first of all. But again, if you're talking about the lands which are included in the within the boundaries of the populated areas, the management of those plots of land must be anyway, or the ownership must be private ownership. The boundaries of the public property or the ownership must manage, but not have this in their ownership, whatever. This management can be exercised by the way of alienation for the social needs and the sale to the private persons. This is position number two. Position number one. The position number two is the taxes. If you switch over from the rentals to taxes, then we'll have a normal market environment because the situation when some of the plots of land are rented or leased out and some not, this is not tolerable for investors. This, first of all, relates to those plots of land which are now under construction, those plots of land which belong to the industrial production or even the commercial construction as regards the agrarian or the agricultural lands. So legislators have at last to regulate whether they are subject to sales or they are subject to the long-term lease or rent, and accordingly the manager of this kind of lease will be the public land bank, but not as a financial institution, but as a manager who manages those lands. Thank you for your attention. That's all. Any questions? I have a question. Please correct me if need be. We need to introduce some changes and amendments into the Constitution. We have to approve a number of laws. We need to develop a procedure of, let's say, taking land from one public owner to another public owner. So please tell me at which stage. Well, if you're talking about the changes to be introduced amendments to the Constitution, more or less understandable. But what is the stage of preparation of the remaining part of the documents? What do you think? Is there a political consensus in place in order to approve those documents, at least in the situation we have today? As for the preparedness or readiness of the documents, you're talking about the plan and documentation. The draft law is already prepared. Yes, for the rest, as far as I know, there was a resolution of the deputy minister for regions, and this document is being worked on. As for other documents, there are some kind of ideas, I would say, but I understand that it's too early to talk about that or to submit them. There are only ideas. But if you're talking about let's say the key project, I mean which would be turnkey approach for all those documents, too early to talk. If you're talking about the united communities, if you talk about that, there be this approach could provoke some resistance on part of some of the MPs or deputies. They would say that we are trying to violate the constitution. I already mentioned that. So first of all, what we can actually make a progress to introduce amendments into the constitution, which have been prepared already. So one clarification before I take the mic to anybody else. So this process will be a kind of will durable. I would say it will take some time because we have some non-regulated ideas. Since this process will take some time, what do you think? Well, maybe it's difficult to say how long it will take. Will maybe this could threaten the implementation of the reform, for example, of those communities which have been already united. Will this not be another break on the way of implementing reforms in those communities? Yes, indeed. The people in the different localities must be sure that they must understand what there is in store for them. Once again, I repeat myself: the draft law which I mentioned, those which were united communities according to the prospective plans, this draft law has been already developed. The question is, can it be adopted without the amendments introduced into the Constitution? You take a kind of classic approach to maybe this draft law won't be adopted. If there are amendments introduced to the Constitution, of course, there will be more possibilities and chances. Actually, the legislators will be obliged to regulate all the issues pertaining to that, because in this case they will have to comply with the norms of the Constitution. While we do not have that, can those communities be able to do that until all this package of laws be approved? Won't we have a kind of failing reform? They declare that we already have some kind of powerful and capable communities which will have the right to dispose of their property, but now we do not understand what will happen to those communities. Maybe there will be the failure of those communities instead of success. Once again, if you're talking about when we decided to unite the communities, the position number one was the budgetary position, saving of the funds number one, and maybe also approaching the direct relations with the state budget, public budget, plus getting rid of the patronage on the part of the state and public administrations. As for the lands beyond the boundaries of the settlements or populated areas, with all the respects of the politicians who declare something, there is law which fixes that beyond the boundaries or borders of the populated areas. By the way, I was my MP myself and was absolutely against that. But the law on the amendments to the land code were adopted. So whatever is located beyond the boundaries of the populated areas belongs to the state committee jurisdiction. So we need to adopt a law which would make provision for the possibility to manage the lands within the United Territorial Communities in accordance with the plan and documents which describe those lands. This is a good way and a way which we could, must follow. There is no big streamlining here because until we introduce amendments to the Constitution, the possibility of adoption of this law is not obvious. I would put it this way. So I can say that it cannot be approved or adopted, but there could be some difficulties on the stage of approval of this law. I have a clarification, one clarification. If the amendments to the Constitution are not adopted, so the reform will not be implemented in full measure, number one. Number two, the communities will not be able to become the owners of their land because those administrative territorial units, which you call the kind of the DAF, if you compared with the role. So there is a big question about the approval of that law, but again, we lack the streamlining even for the communities to use that. So will they be able not to dispose but to manage those lands? Do I understand properly that even without the adoption of the amendments to the Constitution, the community will have the right to do that? If you are talking about management, yes. If you mean the property or the ownership, then we have to introduce amendments to the land codes regarding the distribution of the management of the public property. Whatever is not the public property, everything must be communal. This is how we should put that in the amendment to the land codes. We have to discriminate between the ownership in the management. Management is the decision making. This is not ownership of property. But again, without the amendments to be introduced in the Constitution, this will be kind of unilateral approach. So out of 179 communities, only 59 actually meet the requirements. So the cabinet ministers has to approve for they meet the requirements. The rest are not meeting the requirements. So I cannot say that all of those united communities are capable to do what they have. We need amendments to the Constitution. I'm sorry, unfortunately, we are run out of time. Thank you very much for your participation. In 30 seconds from now, we are going to have another briefing for the A2 events. If you would like to continue your communication, can do that beyond the boundaries of these premises. So